it's a murder case, and even though you can't go to jail as a result of what happens here, obviously the stakes are pretty high for you financially, and I'm aware that there's a criminal investigation, or at least there was at one point in another jurisdiction, and so that raises the issue of some kind of complex and important Fifth Amendment rights that you have, some of those which are implicated in pleadings that are before me at this point and are likely to come up at trial if this case goes to trial. And I know that from some of your pleadings you've asserted your Fifth Amendment right to refuse to answer some questions, and while you have the right to do that, you can't simply say, I'm not going to answer, I assert my Fifth Amendment right, and then kind of look the other way. If you don't answer questions in a civil case, I can take an adverse inference based on some of those responses, and I'm sure counsel may ask me to do that. Unlike a criminal case, you don't enjoy a lot of the constitutional protections that you would have in a criminal case. For example, I can't appoint counsel to represent you in this case. You don't have a right to counsel in a civil case. Even though the petitioner still has the burden of proof in this matter, it's a much lower standard. It's not a case where they have to prove their case beyond a reasonable doubt. It's a constructive trust case. I expect the petitioner is going to take the position that they have to prove their case only by a preponderance of evidence, which is the lowest standard in a court. You can be compelled to give information in this case. You've already been served 2 sets of interrogatories and a request for production of documents. In a criminal case, the state can't do that. I expect at some point counsel is going to want to take your deposition. You don't have your deposition taken in a criminal case if you're the defendant. And you can be called as a witness in this case. If you don't want to testify, the other side can still call you as a witness. And so you really need to think about those issues as we move forward, moving toward trial. My job is to make sure that both sides get a fair trial. And while I intend to do that, I can't give you legal advice or tell you when to object to a question if it's improper. Those are all legal issues that come up in the course of a trial, and I'm urging you in the strongest way that I can to get counsel to represent you in this matter. If you were a lawyer, I would be telling you to get a lawyer in this case because you have important rights, and I want to make sure that those rights are protected. So do you have a sense at this point, Mr. Carman, whether you plan to retain counsel or whether you really plan to go on your own here?
Yes, I do have a sense of that. I am not comfortable being here either. I do not want to be representing myself. However, there were substantive disagreements and long-standing concerns that I had with Hubert Santos, which made me feel that it was necessary to terminate his attorney's first representation of me at the time that I did. 2 weeks ago today, I put my house on the market, and I am hoping that that will sell quickly. And my intent is to use those funds to finance an attorney as the first priority, even before seeking housing for myself. So yes, I am certainly prioritizing obtaining counsel, and I definitely want to do that. As far as my understanding of what you just explained to me, I believe I understand most of it. For example, the differences in the standard of proof and so forth. I do not understand the legal aspects or the detailed legal aspects of the Fifth Amendment privilege. I understand adverse inference, but I don't, but beyond that, I understand that I have a right to assert the Fifth Amendment, but you can draw an adverse interest. Beyond that, I don't have a solid grasp of the details, and I'm hoping that I'll be able to obtain an attorney's assistance in the very near future to assist me with that. But my concern, it's not the money. It's not so much even my freedom as it is my reputation and seeing that I have a future going forward. And I understand that that is what is in jeopardy here. And I'm very concerned about protecting my future.
It does, and you understand, sir, that I can't advise you on the intricacies of the Fifth Amendment and how they apply in a civil case and how they might interact with matters that may be going on in other jurisdictions. That's something, at least for now, you're on your own to figure out until you do get counsel.
I understand that.
Okay. So let me run down what I see as kind of the agenda for this morning, and either side can tell me if some of these issues have already been resolved or if there are things I'm missing. I have the motion to amend and file exhibits under seal, which is my index number 36, and I've already issued a preliminary ruling on most of that pleading, but there's a couple things I want to come back to. And I guess going along with that, the union leader has filed a motion to unseal documents in this case. It's index 45. It was just filed March 30th, so it's not ripe yet. I'm not expecting that we're going to argue that this morning, but I just want to point out that counsel and Mr. Carman have 10 days from the date it was filed to respond. I'm not sure if Mr. Hayward is here this morning. Good morning, Mr. Hayward. The motion that I have has some, I'm going to use the word redaction. I'm not sure if it's meant to be a redaction, but there's some heavy black lines drawn through it, and I just want to make sure that's the pleading I'm supposed to have in the file.
Please, yes.
Okay. And so whatever you've scratched out is something I don't need to worry about.
You don't have to.
Thank you. I guess the big issue on the agenda this morning is petitioner's motion to compel. I'm going to call it motion to compel number 1 because there's another motion to compel that's not ripe yet that we can discuss briefly. Mr. Carman has not filed an objection to that, but I still want to talk about it this morning and give him a chance to weigh in if he has anything to say. And I think that sort of a companion issue to the motion to compel is the petitioner's motion to file Exhibit D under seal, which, if I understand correctly, is actually you're making that request on behalf of Mr. Carman. It's not really you're requesting.
That's correct, Your Honor.
Okay. I would like to discuss that this morning. I have the second motion to compel. It's my index number 43. It was filed on March 26, so that's not ripe this morning. And Mr. Holmes has filed an appearance. Mr. Holmes.
Good morning, Your Honor. I'm Alexandra Cody. I also filed an appearance on behalf of Glenn
Okay.
Turk.
Thank you, Ms. Cody. And I don't know who Glenn Turk is, so
Oh, sorry.
perhaps before we leave here today, I can figure that out.
Yes, Your Honor.
Okay. All right, so let me begin with the motion to amend. As I said a few minutes ago, I've already granted part of that. And when we were here in December, I had a number of issues that I saw in the case that I wanted to get resolved sooner rather than later. And I think, if I understand it correctly, the intent of the motion to amend was to address those issues. Mr. Sadler, you're on.
That's correct, Your Honor.
Okay.
We're aware of the issues you brought up, so that is the reason for the amended petition, and we hope that they have addressed the issues that you
Okay.
brought to our attention.
So I can see that the situs of the trust was changed prior to the filing of the petition, although days prior to filing the petition, it looks like.
That is correct.
And then there's a new footnote in the amended petition, footnote 1, that says that Linda Carman is constructively dead. There's no case law, and I'm just wondering if that has a specific legal meaning or if there are proceedings in another jurisdiction that have to do with Linda Carman's death, or if that's something I need to be concerned with at this point.
There are no proceedings at present in any jurisdiction of which I'm aware addressing that issue. I note that in your December order, you wanted us to make clear well before the May 21 hearing to actually focus on that issue for you, and we intend to do that.
Okay. And am I reading correctly that under the current state of the estate planning documents and the trust, that Nathan is a current beneficiary of at least one of the trusts?
That is correct, Your Honor.
Okay. And that he would take under that trust regardless of whether his mom was still alive or not?
He would come into he's in a beneficiary status, and that would become effective. It already is effective with regard to that particular trust. The other trusts, he's, I'm going to call it a contingent beneficiary, and that status will improve to become an actual beneficiary of the trust once her status is resolved.
once Linda Carman's status is
Yes.
resolved.
If her status is resolved, that she is declared dead in one fashion or another, by some state law or another, yes, that will effectuate a change in Mr. Carman's status to become a current beneficiary.
Okay, but I think everyone understands, I have no jurisdiction to make that determination.
Yes, we understand that.
Okay.
If I could weigh in on that, Your Honor?
Sure.
Firstly, where the petitioners have just alleged that I am a beneficiary of at least one of the trusts, let me state that I have never been informed at any point in my life that I am a present beneficiary of any of the trusts that I understand should be mentioned in this petition. The only trust that I know that I am a beneficiary of is the Nathan Carman Family Trust, which was established during my grandfather's lifetime, funded during my grandfather's lifetime, in which I understand my grandfather had no relationship to after the year 2012. So that is what the petition you just said is news to me. It's
Okay.
my understanding that the trustee would have had an obligation to inform me if in fact I was a beneficiary, and that was not done.
The amended petition alleges that you are a current beneficiary of the Rita B. Chakalus Personal Residence Trust. So I think you'll find that in, it's my index number 37, but it's the new amended petition that makes a few changes to the original one. So I guess just another reason why you really need to seek counsel to find out what your rights are in this matter, Mr. Carman.
Yes. And additionally, where the counsel, we were just talking about proceedings in other states regarding the legal status of my mother as a deceased or not deceased. This also goes to who Glenn Turk is. In December of 2016, there was a proceeding in the Middletown Probate Court to declare my mother a missing person and appoint Glenn Turk as a trustee to basically maintain the status quo of her property under a Connecticut statute. And the petitioners filed a motion in connection with that proceeding, asking the court to declare that my mom was a missing person and to appoint Glenn Turk, or at least a motion to appoint Glenn Turk as trustee. And I have a copy of that motion with me. So as far as what petitioners have done in the court to affect my mom's status one way or the other, they have taken a position in favor of her being a missing person at this time.
Okay, thank you. And Attorney Cody's here to represent Mr. Turk this morning, so we'll talk about that in a bit. All right, I guess maybe the next thing I'd like to move to then, Mr. Sadley, is your motion to compel. I have read the pleading and the attachments. For the record, it's index number 30 in my file, and I understand that you're taking the position that some of Mr. Carman's responses to both the interrogatories and the request for production of documents are not sufficient. The problem is I don't have his answers. I have your motion, I have a letter that you sent him, I have his response, but I don't have his actual answers. So at some point before I can resolve these issues, I'm going to need to see exactly what his answers were. I know in your letter you kind of paraphrased some of the things, but I think it would be helpful if I could actually see what he said.
Your Honor, with regards to the motions to compel, Attorney Small is going to address the issues.
Okay. So again, I didn't get a response from you, Mr. Carman. I'm certainly going to give you a chance this morning to respond, but again, just want to point out that under the rules of the circuit court, when the other side or you file a motion, there's a 10-day window in which to file a response in most cases. And if you fail to file a response, I can rule on the pleading without hearing from the other side. I don't want to do that right now because you don't have counsel, and that's why one of the reasons I scheduled a hearing this morning so that we could have a hearing on this motion. And again, I'll give you a chance to respond, but I point out for you that you can't just ignore what the other side files. Even if you think it's a frivolous motion, you still need to file a response until you have counsel. Do you understand that?
I do understand that, Your Honor, and it's a challenge for me. I understand the importance of these proceedings. it's also a challenge for me just to face every day with the emotional things that I'm still going through. And I'm trying to balance being able to face every day with facing these matters. I understand the deadlines of the court, and I understand those can be inflexible. But that is part of where I am coming from.
Okay, I understand that, sir. All right, Mr. Small, I'm not sure that I want to necessarily go through everything verbatim in the motion. I have probably more general issues. Is there anything you want to just say as by way of preliminary?
Yes, first of all, Your Honor, if I may approach, I provide the court with copies of the respondents' responses to both the interrogatories, the first set of interrogatories and the document production. I apologize to the court. I think there are a few yellow highlights there. I'll be happy to substitute a clean copy later on.
And I assume, Mr. Carman, that you have these documents since it's purported that you...
Yes, I have with me the answers that I furnished
Okay.
to opposing counsel.
Thank you.
Just very briefly, Your Honor, if I may, the petition was filed obviously last July. Discovery has been badly delayed and grossly inadequate, and the family is frustrated by it. We have bent over backwards, I think the record reflects, to accommodate, providing multiple continuances, providing multiple letters seeking to resolve these issues without the need for court intervention. And the respondent has shown a pattern of refusing discovery, both in this case and also in the Rhode Island insurance case relating to the sinking of his boat, in which we provided a supplemental pleading to the court the other day, attaching a copy of the federal court's order granting the third motion to compel discovery from Mr. Carman in that case.
I actually got that this morning.
I'm sorry, it just was issued the other day. So they've had to go through 3 motions to compel. The court mentioned we filed our second, and we will be, it looks like, filing our third next week. We again sent a letter trying to resolve those matters. I just want to try to narrow it down to 3 broad issues, if I might. One is the Fifth Amendment. The second is the refusal to provide access to documents that he has ready access to. And the third is the refusal to provide answers or documents relating to his mother's disappearance.
And am I correct that the Fifth Amendment wasn't an issue in the Rhode Island motions to compel?
It was not. He simply refused to answer and didn't refer to any basis whatsoever. The order makes a brief reference to the Fifth Amendment, but it was not front and center in the Rhode Island case. The Fifth Amendment issue, Your Honor, arises first and foremost out of paragraph 19 of the police affidavit that was filed in Connecticut in 2014, finding Mr. Carman to be a risk of injury to others. Paragraph 19, just very simply, says that Windsor Sergeant William Freeman learned that Nathan Carman purchased a Sig Sauer 716 Patrol 308 caliber rifle from a gun store in New Hampshire. This is consistent with the same caliber weapon used in the homicide of John Shakalos. Nathan thus far has concealed this information from investigators and failed to disclose this weapon during any interviews with Windsor police. In our discovery, we have sought to obtain details and documents relating to what we believe is the murder weapon, which the respondent claims he somehow managed to lose.
And that information is not available from any other source at this point?
The affidavit, although it referred to a purchase from a gun store, it did not provide either the backup documentation or the name of the gun store. There are 600 licensed gun dealers in New Hampshire. We could subpoena every one of them, but that obviously would be an absurd waste of time and waste of resources. The police have taken the position, and we understand it, that this is an ongoing investigation, ongoing criminal investigation into Mr. Carman, And they are not going to, as a policy matter, they do not provide documentation during an ongoing investigation. So no, we are trying to, a number of different ways to get that information, but one of them, obviously, and the easiest one, is directly from the respondent. There are 4 inquiries to which Mr. Carman refused to answer based upon his Fifth Amendment right against self-incrimination. Interrogatory number 4, we asked him to identify what firearms he owned, and he refused to answer based on the Fifth Amendment. Interrogatory number 5, we asked him to identify the shooting ranges that he used and practiced at, and he refused to answer based on the Fifth Amendment. Document request number 6 and number 5 and number 6 parallel those two. Document request number 5 asked for documents relating to his ownership of firearms. He refused to answer based on the Fifth Amendment. And document number 6 asked for documents, document request number 6 asked for documents relating to shooting ranges, and he refused to answer based on the Fifth Amendment. There are 4 things that need to happen for a valid exercise of the Fifth Amendment. There needs to be compulsion, there needs to be testimony, there needs to be incriminating evidence, and there needs not to be waiver.
And doesn't the information sought have to be relevant and admissible?
Sure, absolutely, absolutely. In terms of the compulsion, obviously, we are compelling to the extent that it's a interrogatory or document request. But this is not testimonial. The law is clear, we cited in our brief, that third-party records are not testimony as protected by the Fifth Amendment. The Fifth Amendment protects personal space inside someone's mind. It does not protect manufacturer's documents, warranties, store receipts, credit card records, all the different types of records that accompany the purchase and ownership of a $3,000 assault weapon. And so we believe it's not testimonial. We also believe that it is not incriminating under the definition provided by the law. In other words, the documents themselves are not incriminating. The cases that deal with production of documents as a serious issue on the Fifth Amendment deal with personal records, someone who kept 2 sets of books and doesn't want to disclose the second one or something like that. But
Wouldn't it not be a link in the chain of evidence necessary to prove the fact that he purchased a gun, which...
No, Your Honor, because in his responses, respondent provided the risk warrant, which says very clearly, as of 3 years ago, that the police are well aware of his purchase of the gun and well aware of his concealing his ownership of that gun. So facts have already been disclosed. There's nothing illegal per se about owning a gun in New Hampshire. And so we believe it's not incriminating in itself. And in addition, we believe that any privilege has been waived, both by the production of the warrant itself by respondent and by the long rambling answers to questions relating to interrogatories relating to the grandfather's death and to the date, events on the date of the murder. You cannot just pick and choose within a topic area where you want to refuse to answer. The last thing is that it would be an abuse of the privilege. The DeMoro case, New Hampshire Supreme Court case we cite, talks about the privilege can't be used as a means of preventing the orderly resolution of civil matters. The police affidavit filed 3 years ago, almost 4 years ago now, talks about a gun store in New Hampshire. They did not attach those records. We understand why. We understand the policy. I mean, I like it, but I understand the policy why they won't provide those records. But as I said, there are over 600 licensed firearms dealers in New Hampshire. We can subpoena every one, but then our concern about when the trial will happen will move into some other decade. And that would be an absurd waste of resources. So that's the Fifth Amendment issue that we see, and we believe that it's an inappropriate exercise of the Fifth Amendment and inappropriate refusal to provide documents.
On the issue of the Fifth Amendment, there was a letter that was sent to Mr. Carman back in February. I'm not sure it's argued in the pleadings, but you indicated that, or I'm sorry, a letter was sent by Mr. Satterley on Freddie Flaherty letterhead that suggested that by answering any of the interrogatories that Mr. Carman has then sort of has a blanket waiver of the Fifth Amendment. I'm curious about what the legal basis for that was.
Not a blanket waiver, Your Honor, but not answering any of the interrogatories, but by specifically answering interrogatories relating to that night, the night of the murder, which is what this is all about. We believe, and by providing the risk warrant as part of his answers, which specifically references his ownership of the gun and his concealment of that ownership, we believe he has waived his privilege both as to interrogatories and as to the document request. Obviously, the document request issue is the easier issue. The interrogatories are more typical testimonial responses, but again, you can't exercise the Fifth Amendment that selectively. You can't weave your responses around the things you don't like and provide responses to the things that you do like. That's just not an proper exercise of the Fifth Amendment.
Okay, but I was curious because the letter specifically says, having answered some of the interrogatories, you have waived your privilege against answering the others. Are you suggesting that the Fifth Amendment can't be asserted with respect to certain issues without?
I'm not suggesting, no, I'm not suggesting that there be a blanket, there is a blanket assertion, or a blanket waiver in that form, that if you answer a question as to one unrelated thing, you have waived it as to something else. But there is law that says you can't be that selective. There is no such thing as a blanket waiver, but there is subject matter waiver when it's, particularly when it's limited to the events of one night and the events in something as narrowly focused as a murder, as this case is. So we believe, I believe that the document request issue is absolutely crystal clear under the law. The interrogatory issue is a tougher issue, as the court notes, but we still think that he has waived as to the interrogatory responses.
Okay.
But our biggest concern, obviously, is to get the documents. The second issue that I mentioned is his access to documents. The respondent has repeatedly failed to provide documents claiming they are not within his possession, custody, or control. But the Zulick case says that a party who has the right, authority, or ability to obtain documents on demand is generally considered to have control of those documents. Here in our document request, in the introduction, paragraph A specifically says documents that are available to you and in the possession, including in the possession of others, and the definition of possession includes joint and several and other persons acting on his behalf. By these standards, it's inconceivable that the respondent does not have access to the very basic documents we've requested. Document request is run through principal ones. Document request number 1 requests his tax returns. Now, my understanding is that we are all required to keep our tax returns. If Mr. Carman did not keep his tax returns, then in our February letter trying to resolve this matter, we provided him with a copy of the standard IRS release form so that we can go to the IRS and get copies of the returns that he failed to keep. We asked for cell phone records. Again, he refused. Again, in our February 26th letter, we said, well, provide us with the cell phone number and the provider names, and we'll go get them. Failed to do that. Document request number 9 asked for credit card records. Again, refused to do it, not in his possession, custody, and control. Again, inconceivable that Mr. Carman would not have any of his credit card records and not be able to pick up the phone and call the credit card company and get them. But in our follow-up letter, we again said, provide us with the credit card numbers and providers and we will go get them ourselves. Same thing with bank statements, and same thing with New Hampshire records. So on all of those items where he claims things are not in his possession, custody, and control, it's very clear that he is taking an absurd view of that term and saying that because he chose to throw them out at some point, we don't know when or how, he doesn't have them. All those records, everyone knows, are readily available to him, and we ask that the court require him to provide them. And the third category is documents relating, and interrogatories relating to Linda Carman's disappearance is absolutely clearly part of the petition. The amended petition has 12 paragraphs, 22 through 34, talking about Linda Carman's disappearance and Mr. Carman's role in her disappearance. And it goes directly to relevance. Mr. Carman, in response to the third motion to compel in the Rhode Island case, raised virtually identical issues, refusing to link the two matters, the grandfather and his mother. And the court again rejected that at page 2 of the court's decision of March 30. The court said the court has already ruled that discovery in this case may focus on facts bearing directly on an alleged scheme to procure a substantial inheritance by murdering first his grandfather and then his mother through the intentional sinking of the vessel, because such facts bear directly on his intent. The court, in this opinion, takes a nautical saying and says that ship has already sailed. I think that's equally true here. He cannot refuse to provide documents and responses relating to his mother's disappearance because he claims that it's not relevant here. Several interrogatories and document requests relate directly to the disappearance of his mother. Those are the three general categories, Your Honor. I'm happy to answer questions the court may have on any of the rest of it.
Well, again, with what I mentioned earlier, the information sought has to be relevant as
Yes.
well, correct?
Absolutely.
Okay. And just for example, the tax returns, tell me how those would fit into what you have to prove at trial.
The tax returns are directly relevant to his sources of income, what monies he received from we're still trying to sort out, and the interrogatories, the responses are intentionally vague and confusing on this, trying to sort out what he received from his grandfather, what money he received from other sources, how to balance that out and figure it out, where he got the $3,000 for the assault weapon when he wasn't working. And so there are a number of financial issues that we're trying to figure out, and if the tax returns end up not being productive in that regard, then they're not. But we're in discovery, we're trying to figure that out.
Presumably, the petitioners have access to the grandfather's checking accounts and bank records and all of that information up to the time of his death, I would imagine.
Your Honor, during the course of the investigation, back in 2014, the police seized a large number of boxes of the grandfather's records. We have spent the better part of a year and a half working to get just the financial records, not the investigative records, back from the police. We just yesterday received a thumb drive representing apparently several boxes of documents. So the answer to your question is we don't know that yet. We don't know what credit cards were in the grandfather's name, what credit cards were in Mr. Carman's name, but paid by the grandfather, or just what that relationship was. And again, ultimately, we will wade through all those boxes and see what they can tell us. But just like wading through 600 licensed firearm dealers, there is an easy way to do this, and it's normal discovery.
I think there was a suggestion, maybe in the question or in Mr. Carman's response about one of the credit cards, that it was actually the grandfather's credit card that he had access to, and if that, in fact, is true, he may not be able to call up the bank and say, give me those records.
If that's the only credit card that he had access to, I don't know. I don't know whether the grandfather, you can put a credit card in dual names fairly easily, and so either party can have access to it. I just don't, the problem is we haven't been given the responses that we need, and so I'm asking the same questions that the court is asking. We just don't know.
Okay. Thank you, Mr. Small.
Thank you.
Mr. Carman, you don't have to tell me anything on this issue. What I have is what I referred to earlier.
May I respond?
Yeah, let me just tell you what I've got, and then you can, so what I've already looked at, and I absolutely give you a chance. I do have your fairly detailed response that you sent to Mr. Satterley when he was asking you for more information back on March 2nd. So I have reviewed that, but please fill in any blanks that you wish, and I do now have your actual answers, which I hadn't seen.
Certainly. Would you like me to take the podium, or may I? Remain?
Wherever you're most comfortable is fine with me.
So, first of all, you hit the nail on the head in suggesting that if an account was in my grandfather's name and I'm being asked to produce records associated with that account, I don't have those records. They're not in my possession, custody, and/or control in the broadest sense of that term, and I am incapable of producing them. That goes for the credit card that I had access to. That goes for my phone records, which was in my grandfather's name. And as it relates to tax returns, the petitioners submitted a request for production asking for tax returns, but they didn't submit an interrogatory asking if I needed to file taxes. It's my understanding that if you don't have an income that exceeds, I believe it's $11,000 in income that's not from gifts, that you're not required to file taxes. And during my grandfather's lifetime, the monies that he was providing to me were in the form of gifts. And after my grandfather's lifetime, I spent most of my time working on a house that I own, where I've not been being paid for my labor. So petitioners ask for tax returns. They don't ask, did you have to file taxes? And I suggest that is a question they perhaps should have asked first. And I did suggest in the response to petitioner's letter that you were just referring to, that if petitioners want to submit interrogatories asking me whose name was your phone account in, whose name was were your credit cards in, or identify your credit cards, I would view those as appropriate interrogatories. But it's my understanding that you can't use a request for supplementation to substantively modify or expand a request for production or a request or an interrogatory. And that was the basis for my declining the petitioner's request for supplementation when their interrogatory, when certain information would not have been responsive to the interrogatories or requests propounded.
So you're saying in the letter that the follow-up letter they sent you, they asked for stuff that they didn't ask for in the original interrogatories or requests for production?
That's correct. And if they want to ask for that, or if they want to ask about it, I would think that's appropriate, but they have chosen not to, and I don't know why. As it relates to bank statements, we're talking, first of all, part of this time I was a minor. I turned 18 on January 21st, 2012. So we talked about starting in January of 2011. I didn't have any accounts in my name, and I wasn't capable of having anything in my name at the beginning of this time period. But referring to bank accounts, this was over 4 years ago. I don't currently have bank accounts that I had in the time period petitioners are asking about. Those accounts are closed, and I don't keep records for 4 years. I do believe I understand the meaning of one's possession, custody, and/or control, in that if I don't have it, but somebody who I can order to give it to me does have it, they have to give it, that I have to then get it from them and produce it. But I don't, like as far as a closed bank account, I don't even know if I can force the bank to give me records on that. And I certainly wouldn't know how to go about doing that. So I don't believe that those records are in my possession, custody, or under control, and that's what I indicated. I did produce all of the records that were in my possession, custody, and or control, including an affidavit that has a testimony from other witnesses referring to the risk warrant affidavit. And Attorney Small seems to be suggesting that somehow by having produced this document, I am making some statement other than I have this document and here it is. It's responsive to your request. The risk warrant affidavit is wrought with intentionally misleading and factually inaccurate information. So to the point of what, like, so it seemed like Attorney Small was suggesting that by producing that document, I was in some way testifying to what's in it or the veracity of what's in it. And that's certainly not my understanding. I don't think that is correct, if that is what Mr. Small is trying to imply. As it relates to the Fifth Amendment issues, or if you'll pardon me, Your Honor,
That's fine.
as it relates to the boat issues, it's my understanding of what petitioners are trying to allege here, not what petitioners are trying. Petitioners are trying to allege a gamut of things, but what petitioners have a cause of action for, allegedly, and what you would ultimately be asked to decide at trial is whether or not I murdered my grandfather. And my grandfather's death is an event that occurred in December of 2013. Petitioners are asking about modifications that I made to my boat in September of 2016. Are we trying 2 murder cases here, or are we trying 1? And if we're trying 2 murder cases, if we're saying that the issues at trial are not just did Nathan kill his grandfather or did he not, but also did Nathan kill his mother or did he not, do we not first need to figure out legally whether or not my mom is considered to be deceased, what's the manner of death, and then by what standard of proof are we trying to determine if my mom, it's difficult for me to repeat the allegation, but if I killed my mom or not. And how does that relate, like even if you did conclude that I killed my mom, how would that relate to your conclusion as to whether or not I killed my grandfather years earlier? It's just, to me, petitioner's argument that the disappearance of my mother relates to their allegations that I killed my grandfather is incoherent. And there is a separate case in Rhode Island that's pending where the insurance company that brought that matter is alleging that I intentionally caused my boat to sink. They do not expressly allege that I committed a homicide. They allege that I intentionally caused my boat to sink. And that case is going going to be going to trial, likely late this summer or this fall. In other words, before this matter that we're here today for is likely to go to trial. So it's likely to be res judicata as far as did I or did I not kill my mother, well before this case gets to trial. And it's my view that having one case focused on the issues relating to the vote, and having a ruling about the issues relating to the vote, and having another case focused on the issues relating to my grandfather, and who did have motive to kill my grandfather. And I'll say that some of the petitioners had awfully substantial motive, and I had very, very little. Having two separate cases, one focusing on the boat insurance and one focusing on the issues relating to my grandfather, is what I've been pushing for in Rhode Island, and that's what I feel is appropriate here. Petitioners conclude the first half of their petition with the statement, these facts support the conclusion, or statement very similar to, these facts support the conclusion that Nathan Carman killed his grandfather. The climax of petitioners subheading B, the disappearance of Linda Carman, is Nathan Carman left his mother behind on a sinking boat. Even if you were to believe that, that's not a crime. And how does that relate to the allegation that I killed my grandfather? I don't see, so even if petitioners were able to prove through discovery what they alleged in their petition, it doesn't relate to their cause of action here. And that's why I feel and have asserted that the petitioners' efforts to seek discovery relating to modifications that I made to my vote about 3 years after the death of my grandfather are not reasonably calculated to elicit information that would be relevant or admissible at trial. And since any response involves a certain degree of burden, I would also say that those requests are unduly burdensome, although admittedly to a limited extent.
So just so I understand, Mr. Carman, I think if I understand correctly, the action that's pending in the federal court on Rhode Island is a declaratory judgment action brought by the insurance company against you so that they don't have to pay for the loss of your boat.
That's correct.
And the petitioners aren't involved in that case at all.
That's correct.
And so any decision that's made in Rhode Island really has no binding effect on me to any degree, and they're not being asked to determine what happened other than whether the insurance policy has to provide coverage for you.
That's correct. However, there is going to be a ruling as to whether or not I intentionally sank. And I would submit that ruling would have more relevance at trial than attempting to retry the question. That's my position.
Well, you used a fancy legal term, res judicata, but that applies in the same. But because the petitioners aren't
and relating to the Fifth Amendment issues, first of all, I'm sorry, I'm trying to compose my thoughts to speak. The petitioners said that I was selective or inappropriately selective in pleading the fifth. And let me submit that there are multiple issues or considerations at play for me. Connecticut has some very harsh firearms laws that are totally unrelated to their homicide statutes. It is reasonable to discuss matters that have nothing to do with firearms, or at least or my involvement or lack of involvement in them has nothing to do with firearms. And to draw a line saying I plead the fifth when asked about did you or did you not purchase this particular weapon. And as far as how Attorney Small says that I claim that I managed to lose this particular weapon, I don't know, because I have never claimed that. I have never. I feel that for reasons unrelated to the allegations that I murdered my grandfather, it is prudent for me to plead the fifth relating to questions about firearms. And I think that that's a reasonable distinction that Attorney Small either intentionally or unintentionally fails to recognize. And as it relates to did I waive my right to plead the fifth by producing the affidavit which I produced. And is any production testamentary? I can't pronounce the word testamentary. You understand what I'm trying to say? I can't pronounce it.
Testimonial?
Yes, testimonial. The police alleged in the affidavit that I purchased a particular firearm. They did not present any evidence to support that allegation. My position is that by being asked to respond to a petitioner's request for production, one, if I did have the documents in my possession, I don't know if I can say whether or not I did without, in fact, waiving, whether or not I do without, in fact, waiving the fifth, or if I ever had them in my possession, or if I ever, I plead the fifth. My position is that the police have made an unsupported allegation. That doesn't mean that they know something. It doesn't mean what they're saying is true. And by being asked to produce documents, that would be being asked to perform a testamentary act, and therefore is inappropriate. I think it's a reasonable distinction to say I'm willing to say I didn't kill my grandfather and describe and answer any questions you have about that. But to draw a line where it comes to firearms, given the firearm statutes that are existing in Connecticut. And I hope I effectively summarized my position on those conditions.
I think I understand your position, Mr. Carman. Anything else that you want to address with respect to the first motion to compel?
No, there's not.
Okay. Mr. Small, anything you want to say in response to Mr. Carman's remarks?
Just 2 points briefly, Your Honor. First of all, obviously it's none of my business why Mr. Carman fired very experienced counsel in this case, but he is represented by counsel in the Rhode Island case, who can certainly explain to him the res judicata or whatever other issues, and also the fact that the court there has repeatedly found now that the two cases are related, and that it's not a matter of entirely one there and entirely one here. The second thing, that this new notion that you might be taking the fifth because the Connecticut gun laws are strict. First of all, the affidavit clearly, the police risk affidavit clearly says that he purchased the gun in New Hampshire. So I'm not sure why Connecticut gun laws would be an issue. And second, again, that does not go to the actual documents, or request for production of documents. If it goes to, if he did something, came across state lines or whatever in his interrogatories, that might be grounds for Fifth Amendment. But it has no bearing on the request for production of documents, which are simply not testimonial and not incriminating in and of themselves.
Well, you've relied to some extent, it's not really developed in the pleadings, but you've raised the foregone conclusion issue, and I think if I hear Mr. Carman correctly, he's saying what's in the affidavit's not accurate. So tell me how the foregone conclusion plays into the Fifth Amendment here.
Well, I mean, it's a sworn affidavit that was filed in court 4 years ago and has never been contradicted until this moment. So the notion that the court should automatically then reject the affidavit, I think is simply not consistent with the law, and it is a foregone conclusion that the police already have known for 4 years that he bought this assault weapon. Therefore, providing the documents relating to that purchase does not implicate the Fifth Amendment and does implicate the foregone conclusion. And the same thing with the firing ranges. The police say in the affidavit that he was fascinated with guns or very active with guns and shooting. So again, they already know that. They knew it 4 years ago. But they did not, and as I said, I'm not criticizing the police. I understand why they didn't attach the underlying documents and why, as a policy matter, they still have an open investigation and don't give out those documents. So we need to obtain them in a different way, and by far the simplest and easiest way is the way that the rules set out, which is to submit interrogatories and submit requests for production of documents.
Thank you, Mr. Small.
Thank you.
Mr. Carman, last word on that. Anything you want to add?
Yes, Attorney Small mentioned that the Court of Rhode Island has, according to him, repeatedly found that the issues relating to the death of my grandfather and the issues relating to the sinking of my boat are related. I don't believe that Attorney Small representation is accurate. Earlier, Attorney Small says that, or said that I refused to answer the something, he didn't specify what, I don't believe, in Rhode Island, and did not give any basis whatsoever. Either Attorney Small has a misunderstanding or he's not being forthright, in that there was, you mentioned 3 motions to compel. I'm aware of 2 off the top of my head. There was a motion to compel, which the court ruled on, and the court modified the interrogatory that was being asked in a way that substantially changed the interrogatory. And we responded to that interrogatory as it was changed. The court just, I believe it was on the 28th last month, that the hearing took place and the ruling was issued, I believe, last Friday. Just came out with this concept that the 2 cases are related. Prior to that, the court had not found, to my understanding anyhow, that the 2 cases were related. And we are, because the ruling just came out last Friday, we are in the process of determining whether or not it's appropriate to appeal to the district judge. And that's something that my attorney in Rhode Island has told me that he's talking to local counsel about. And that's a decision that he's going to make and tell me this is what I decide. But as far as Attorney Small's suggestion that the court in Rhode Island has repeatedly found that the 2 cases are related, I would submit that that is not accurate.
Okay. The other issue that's related to the motion to compel is Mr. Satterley's motion to file Exhibit D to the motion to compel, which was actually your response, Mr. Carman, under seal. And I gather from my question to Mr. Satterley earlier this morning and from what I see in the record that he did that as a favor to you. So even though it's Mr. Satterley's motion, I'm going to ask you to tell me why Exhibit D, which is your response to Mr. Satterley's letter, should be subject to the protective order in this case.
Okay.
And the protective order, just for everybody's recollection, was entered into by your previous counsel on your behalf while he was still representing you. I assume you're familiar with the document.
Yes, I am. I'm familiar with the document. Not intimately so, but I have a working knowledge of it. So first of all, the document, the protective order requires that if I were to designate any document as confidential subject to protective order, and submit it to petitioners, petitioners would have an obligation to file it under seal, at least according to my understanding, and that after I didn't bring the protective order with me to refer to, but that after a period of 30 days, I would have an obligation, that the default is if it's designated confidential subject to protective order, that it's under seal, and then I have, after a certain period, I have an obligation to support that. And that's not what petitioners did. Petitioners just threw a document that was designated confidential subject to protective order out there, not under seal, and their motion to seal it, my understanding is that's patching up their mistake, not so much as a favor to me.
If I read the protective order correctly, it protects documents that contain information that's protected from disclosure by statute, or that should be protected from disclosure as confidential personal information, trade secrets, personnel records, or commercial information. So it's kind of a designated, limited group of documents or things that would be subject to this protective order, not just here's a letter and I want it to be subject to the protective order. So can you tell me which of those categories your response falls under that would allow it to be, in essence, sealed?
I'm sorry, Your Honor, but I don't know the categories off the top of my head.
I'll read them again. I'll go slowly. So protected from disclosure by statute, or protected from disclosure as confidential personal information, trade secrets, personnel records, NNEL, or commercial information. And it refers specifically to Rule 35E.
I can say that it was my understanding that responses to interrogatories or anything that was derived therefrom was covered by the protective order, and that it was my understanding in submitting this letter that it was a supplement to my responses to interrogatories, and therefore covered by the protective order. That was my rationale in believing it was designated confidential subject, that it was appropriate to designate confidential subject to protective order.
Okay.
I would also point out that the letter mentions the locations where certain accounts were held, and that could be considered confidential personal information.
Okay. Mr. Satterley, anything you want to add? It's actually your motion.
My motion, Your Honor, as we made clear in the motion, motion, it was a request from Mr. Carman that that document be actually filed under seal. We accommodated that in accordance with the steps of the protective order. But as we've identified in the protective order itself, it's limited to certain classes of information. We did not think that this letter, we don't believe it qualifies under any of the categories that you read. So therefore, while we've accommodated his motion, we are in fact suggesting that it is inappropriate for designation as a confidential subject of protective order.
And are you agreeing with me that the section of the fairly lengthy agreement that I've highlighted is in fact the categories of protected information that are subject to that agreement?
Paragraph 3.
Okay, well, I will take all of the issues we've talked about this morning with regard to motion to compel number 1 under advisement, and I'll issue an order as quickly as I can. Mr. Carman, there's another motion to compel, which, as I mentioned at the outset of the hearing this morning, was filed more recently. We date stamped it in on March 26th. Again, that's a 10-day motion. The 10 days aren't up. You don't have to file a response, but I can rule on that after 10 days, regardless of whether you file a response. So my preference would be to hear from you with regard to motion to compel number 2 so that I know what your position is. Okay, do you understand that?
I do understand that. I'm not prepared to speak on it.
I'm not
at this
we're not
time.
going to take it up this morning.
Yes, but I will make an effort to have a response by the deadline.
Okay.
Your Honor, if I might, just on that motion, obviously we're happy to come and have a hearing on it. I will say that the issues underlying that motion, the court will see, are pretty much the same issues that we've gone through today on additional and further questions and further requests for production. So,
Understood, Mr. Smolin. Unlike the first motion to compel, I do have the benefit of having Mr. Carman's answers, so that I'm a little bit further ahead on motion to compel 2 than I was on number 1.
and we'll make sure that number 3 has the answers as well.
Okay,
And I think that will be similar issues as well.
Okay. All right, the other thing that I mentioned at the beginning, and I think Mr. Carman shed some light on this, but Glenn Turk, who was represented this morning, anything that you want to put on the record this morning?
Yes, Your Honor, I just wanted to explain who Glenn Turk is. That might be helpful for you.
That would be helpful, because he's not mentioned in any of the pleadings, he's not a part of the record, there's no motion to intervene, and although we've got 2 appearances, I guess you need to help me out a little bit.
Yes, of course, Your Honor. So Ralph Holmes and I represent Glenn Turk, who, as Mr. Carman correctly pointed out, is the trustee of property for Linda Carman. He was appointed by the Connecticut Probate Court. I do have copies of the court order of his appointment, if that would be helpful.
Have you seen that document,
I
Mr.
have
Carman?
enough.
I believe
I think you alluded to it earlier.
Yeah.
Any objection to me seeing it?
Which document?
I think it's the order of the Connecticut Probate Court appointing Mr. Turk.
No, I don't have any objections to your seeing it.
Okay.
I have 3 copies, Your Honor.
I'm not going to formally mark it, but I'll just take it as sort of some background information.
Yes, of course. So the order basically appoints Glenn Turk as the trustee of property for Linda Carman. It also suspends the effect of a verbal power of attorney that she had executed in favor of her friend, Sharon Hartstein. And Sharon and Glenn Turk have entered into a delegation agreement, which is referenced in the order, which provides expressly that Glenn Turk retains sole authority for managing and protecting Linda's beneficial interests in the estates of John and Rita Shacklos, as well as any trust created by either John or Rita.
Specifically the estate that's open and pending in Cheshire County.
Correct.
Okay. That's helpful.
Do you have any further questions?
I don't, Ms. Cody, thank you.
Thank you.
All right, I think that concludes the list that I had. Is any other issue that I need to be concerned with this morning?
Nothing further from us, Your Honor.
Okay, Mr. Carman, anything else that you want me to consider this morning?
No, there's nothing else that I would ask you to consider. I'm not sure if this is appropriate to ask here, but I don't know where else to ask it. So I understand that one potentiality is that you would order me to produce documents that I have said are not in my possession, custody, and/or control. And these documents are not in my possession, custody, and/or control. So I'm just not clear as to if if petitioner's motion would be granted, what the appropriate way to respond would be, given that I don't have the ability to produce the documents you're asking me to produce.
Well, I guess what I would say, having heard your arguments this morning, Mr. Carman, I understand what your position is, and I will try to craft any order in such a way that takes that into account.
Okay.
All right? You are, I understand, looking for a lawyer. I hope that goes well for you. I hope you're successful in your real estate deal, if that's what you need to do in order to get counsel. We do have another hearing scheduled in May, so I'm hoping that maybe before that time, things will change so that you will have a lawyer at the next hearing.
That is my hope as well.
Okay. All right, I'll take this matter under advisement. I'll get an order out as quickly as I can. Thank you very much.
Thank you, Your Honor.